In general, in the United States, conflict resolution is characterized by a win-lose philosophy. Americans approach disputes with an attitude that one party is wrong, one is right, and the purpose of dispute resolution is to decide who is right. Americans also believe that to the levels legal system is time-consuming and expensive, it can determine right and wrong. As a general statement, most Americans respect the legal system and the law, though they find the process of litigation time-consuming and expensive. The uses of various forms of ADR are difficult to assess as much occurs in private, non-reportable settings, and there is no national or centralized form of regulation of dispute resolution in the US. Dispute resolution and its regulation in the US inherently complex, involving both national, what we call federal, and state regulation with 50 different states, and a great variety of informal and private processes that remain largely unregulated in the public sphere, though sometimes scrutinized in public litigation when constitutional, contractual, or other challenges are made. Dispute resolution in the US is now characterized by multiple or parallel tracks, which is known as process pluralism. Parties, depending on their economic and legal circumstances, may often choose between formal legal proceedings or less formal forms of dispute resolution. On the other hand, some parties may have no choice at all, such as the helpless consumers and the employees who are required to agree to mandatory arbitration processes in their form addition contracts.
The present legal system in Korea has been constructed from the West by Japan and is modeled on the civil law system of Europe. Civil law systems are based primarily upon written codes. In the United States, the legal system is based upon the common law system of England. Common law systems are based upon codes but also on judge-made law. Both the civil and common law system venerate the rules of law, which holds that a law rather than some person, division, or political group controls legal and governmental matters. In addition, law is to be used to decide legal matters and not as a tool for political advantage. However, the rule of law has yet to be as widely accepted in Korea and remain an obstacle to democratization. In general, Koreans approach disputes with an attitude that all parties are partly wrong or partly right. Disputes are to be resolved in indirect and non-confrontational ways so that harmony is restored and the relationship between the parties returns to one of harmonious interaction. Koreans have little respect for the law and the legal system to depend upon non-legal techniques to resolve disputes. Korea has enacted the Korean Arbitration Act (KAA) in 1966. The KAA established the Korean Commercial Arbitration Board (KCAB) in Seoul to handle arbitration of commercial disputes. This body also provides mediation and conciliation service. In 1990, revised in 1992 and 1995, it enacted the Civil Mediation Law for court-ensured mediation. Both processes are, however, seldom used. Another example, in a dispute between the government and a contractor in Korea, the government has a great deal of power and is at the top of the status hierarchy, while the contractor is low on the hierarchy. Yet, the government may need the services of this contractor in the future or may fear that it will rise if it proves to be difficult to work with and gains a poor reputation. The government is thus likely to resolve the dispute at least partially favorable to the contractor. In Korea, the court system is used primarily to dispense criminal law and sanction criminals. Comparatively speaking, the legal system adjusts the case few civil dispute. The reason for the lack of civil case adjudication by the court is that appeal or compromise prior to any court action being filed is so common, it is rarely necessary to resort to a judicial process. This is changing and more suits are being filed in Korea. In contrast, in the United States, It is common to file a case in the court system and later settle. Approximately 97% of all civil cases are settled prior to trial.
Case study. For example, Brett in her book Negotiating Globally gave the following example of dispute resolution in China, which could very well occur in Korea. United States company had a contract from a German buyer to sell bicycles produced in China. When the first shipment was ready, there was a problem. The bikes rattled. The United States buyer did not want to accept the shipment, knowing that with the rattle, they will not be acceptable to the German customer, whose high-end market niche was dominated by bikes that were whisper quiet. What to do? In the United States culture, the normal approach would be to tell the manufacturer that the rattling bikes were unacceptable and that the problem had to be fixed. In China, such a direct confrontation would be extremely rude and cause much loss of face. Knowing this, the United States manager went to the Chinese plant, inspected the bicycle, wrote a few, and asked about the rattle. Is the rattle normal? Do all the bikes rattle? Do you think the German buyer will think there is something wrong with the bike if it rattles? Then he left. The next shipment of bike had no rattles. In such a cultural context, it is not surprising that both lawsuits and formal arbitration are used less in Korea than in the United States. The Korean people do not think it is virtuous to resort to the law. In the United States, resort to the law is considered an avenue for proving the virtue and rightness of your cause. Power imbalance among disputants have more of an effect in Korea than in the United States. In the United States, parties are supposed to be equal before the law. A doctor, a person of power and importance, is not to be given any preference over a patient or person of less power and importance in a case. However, in Korea, a doctor is to be judged only by doctors, not by a jury taken from the population as a whole as in the United States. Koreans are more likely to believe that the doctors will side with the doctor litigants than the patient litigants. Because juries are taken from the population at large, at least for the most part in the United States, just the opposite is true. American juries tend to favor the less powerful person in a lawsuit. For the conclusion, the legal culture of the Korean people remains basically hostile to adjudication processes such as litigation, government-provided adjudication process, and even arbitration, private adjudication process. Koreans tend to use face-saving negotiation as the primary dispute resolution mechanism. It is generally true that Koreans prefer peace to justice, harmony to truth, negotiation to adjudication. Thus, face-saving negotiation is still the most popular form of settling disputes in Korea today. While cultural factors will certainly play an important role in shaping the approach of Korean parties to dispute settlement, United States firms should be able to settle a dispute with a Korean client easily if respectful negotiations are utilized. United States companies need to not fear the costs associated with litigation or arbitration, which are very real possibilities in the United States market.